We have breaking news for you out of Washington. In a new court filing, the Department of Justice says that former President Trump can be sued by U.S. Capitol Police over the January 6th insurrection. I want to bring in NBC's Ken Delanian back with us, Tali Farhadian Weinstein. Ken, what more can you tell us about this ruling?
Chris, this DOJ opinion holds that President Trump does not have absolute immunity from multiple civil lawsuits filed by police officers and members of Congress, which seek to hold him liable for damages stemming from the January 6th.
Judge Amit Mehta rejected Trump's broad claim of presidential immunity, using Trump's own words as evidence in a ruling that fundamentally reshapes the January 6th cases. The decision strips away the legal shield Trump has relied on for years, with major implications for his civil and criminal liability moving forward. For years, Trump has been hiding behind this one simple, elegant, and surprisingly effective legal theory that basically says, I'm the president. Everything I do is official. You can't touch me. That's been his entire legal strategy since the Capitol attack happened. And honestly, it actually worked for a while.
Here it's an opinion from Chief Justice John Roberts finding that former presidents are entitled to absolute immunity for official acts, but not for unofficial acts. So what does that translate to? Well, this is something we saw that was sort of signaled in oral argument, because what this means is that the former president cannot be prosecuted for anything that was officially part of his job when he was in office. And that's significant because even his own lawyers conceded during oral argument that not everything that is alleged in this indictment was an official.
The Supreme Court had already reinforced that argument in 2024, granting presidents substantial immunity for actions considered official. Trump's legal team seized on that ruling and pushed it as far as possible. Their position was that everything he did that day, the speech, the calls, every single action was simply part of carrying out his duties as president. Protected. End of story. Nothing more to discuss. That was their case. And for quite a while, it appeared to be effective, at least enough to leave this particular lawsuit trapped in legal uncertainty for years without ever advancing to a real trial. But there is a limit to any legal shield. It only protects someone when the conduct behind it actually qualifies for protection. Judge Amit Mehta examined that defense closely, tested its boundaries, and concluded that there was a major hole running straight through the center of it.
Oh, look, all I want to do is this. I just want to find 11,780 votes, which is one more than we have, because we won the state.
Senator, it is so specific what the president is asking of the Georgia Secretary of State. Another description that I did read in just a headline from the Washington Post, Trump alternately begs and berates the Raffensperger to overturn President-elect Joe Biden's win in the state of Georgia.
And it wasn't only the speech. Mehta also determined that Trump's notorious call to Georgia's Secretary of State, the conversation in which he pressed for roughly 11,000 additional votes, was not shielded either. The judge's reasoning, paraphrased, was straightforward. That was not a president carrying out official duties. That was a candidate trying to reverse an election defeat. Legally, that distinction is enormous. Still, this was not a complete loss for Trump. Mehta indicated that some other conduct from that period, including comments from the Rose Garden and certain conversations with Justice Department officials, could still qualify as official acts. Trump may also raise immunity arguments again once the case reaches trial. So this is not an automatic finding of guilt. The real takeaway is narrower but significant. Trump's sweeping claim that everything he did was protected has now been seriously weakened.
Brought against former President Donald Trump by Capitol Police and Democratic lawmakers over the January 6th riot at the Capitol can now move forward. A three-judge panel of federal appeals court judges announced that ruling today. The lawsuits accuse former President Trump of inciting the violent mob that stormed the Capitol. Trump's attorneys asked the appeals court to dismiss the suits, claiming presidential immunity. The panel says it has no views on that issue, but will allow the case to continue. Trump has said if he is reelected, he plans to pardon many of those prosecuted for their involvement in the Capitol.
And that opening now points toward an actual trial with real stakes for the people who were present that day. The case is known as Lee v. Trump, and it was filed by a group of Capitol Police officers and members of Congress who personally experienced the events of January 6th. They are suing Trump as an individual for the harm they say resulted from his action. Several officers described being injured, pinned near entrances, exposed to chemical irritants, and pulled into the crowd during the chaos. This is not simply a theoretical dispute about presidential power. It involves real plaintiffs describing real consequences from a real event. And for years, they have been waiting just to learn whether their lawsuit would even be permitted to continue. This ruling means the case survives. It can move toward a jury, possible financial damages, and potentially a deposition in which Trump could be questioned under oath about one of the most consequential days of his presidency. https://w www.youtube.com/watch, sinal de igual wo 8 biro e T sinal de igual 63S 5,0 2 até 5,36.
August 28th, Anderson.
Despite warnings from federal judge Tanya Chutkin, who's overseeing the federal 2020 election case, the former president continues to rage against her on social media. What options does she have, or any of the judges in these 4 criminal cases, have to stop him? Because, I mean, none of the majority of Republican candidates running against the former president are backing him on his critiques and his, attempts to destroy law, the justice system in this country, essentially.
And naturally, how did Trump react to the decision? Did he accept it calmly and offer some restrained statement about respecting the courts? Of course not. His team dismissed the ruling as a baseless Democratic hoax. Trump, meanwhile, has spent months attacking judges who rule against him, calling them irrational, dishonest, and accusing the courts of being politically weaponized. He has even claimed that certain judges suffer from what he calls Trump derangement syndrome. That is not an actual medical condition. It is simply another way of expressing his anger when the legal system does not deliver the outcome he wants. And by now, the pattern has become so familiar that his response is almost predictable before he even makes it.
Trump that blank check. He was doing a whole lot of damage to federal employees in the country even before the shutdown. I mean, remember Elon Musk and his chainsaw, and they did a huge amount of damage in their so-called big, beautiful bill, which was beautiful for billionaires, but not for others. And when they extended the tax cuts for billionaires, the one tax cut that they did not extend was that helps middle-class Americans afford their...
What makes this story especially important is that 2 very different courts dealing with 2 very different areas of law are arriving at a similar conclusion about the limits of presidential power. This is not simply one lawsuit moving forward. It is part of a broader judicial resistance to the idea that the presidency gives any president unlimited legal protection. And this is where the headlines can become misleading. Trump has not been convicted of anything here. This is a civil case, not a criminal prosecution, and this ruling does not send anyone to prison. But it is also wrong to dismiss the decision as meaningless procedure. The ruling matters because it determines whether these lawsuits can continue and whether Trump's claim of immunity actually covers the conduct being challenged. To understand why, go back to the Supreme Court's 2024 immunity decision. The court gave presidents broad protection for official acts performed while in office. Core constitutional duties can receive absolute immunity, while other official conduct may receive presumptive protection. But personal or private actions that are outside the president's official responsibilities receive no presidential immunity at all. That distinction is now at the center of the January 6th litigation. Judge Amit Mehta had to determine whether Trump's conduct reflected presidential duties or political activity by a candidate trying to remain in office. According to the ruling described in the video, Mehta examined the Ellipse rally closely. The White House did not organize the event, taxpayer money was not used to stage it, and official White House channels did not promote or publish the speech. That supported the conclusion that the rally looked far more like campaign activity than an official presidential function. The ruling also addressed Trump's words themselves, finding that the plaintiffs could plausibly continue arguing that some of the speech amounted to incitement rather than fully protected political expression. That does not mean a final judgment has been reached, but it allows that issue to remain alive in the case. The Georgia call is another major example. Mehta viewed Trump's request for enough votes to change the result not as official presidential business, but as the conduct of an office seeker pursuing an electoral outcome. Still, the ruling was not a total defeat for Trump. Some actions may remain protected, including certain conversations with government officials. The judge evaluated each act separately rather than issuing one sweeping judgment, and that is the real takeaway. The lawsuit survives, but Trump has not automatically lost it. Discovery, depositions, evidence gathering, further motions, and appeals can still take years. This is not an instant courtroom reckoning. It is a long legal process. But taken together with other recent court battles over presidential authority, the broader message is becoming harder to ignore. Holding the presidency does not automatically transform every political or personal act into protected official conduct.